showing that we have total about 3 hours left, which is about right. We really have about 2 hours and 45 minutes with our afternoon break. Plaintiff has an hour and 12 minutes. Defendants have an hour and a half.
Thank you, Your Honor.
So that's what I have, but I'm not sure it's accurate because we spent a lot of time this morning, and so I'll be fair about how we divide that time. If we need to go a little bit over, we can.
Thank you, Your Honor.
All right. So we'll have Mr. Stock come back up. You can take a seat. You're still under oath. And Mr. Pack, you can proceed with your cross-examination.
Thank you, Your Honor. Mr. Stock, you said in paragraph 38 of your declaration that we did not attempt to divide that amount between equipment and routes between the two because there was no appraisal of the trucks available at that time. And I think you were referring to the time the 2024 settlement agreement was entered into. Was it your intention to get an appraisal at some point after the execution of that 2024 settlement agreement?
No, I didn't, because the classifications of what we were doing, like I said, on the knowledge of what both Charlie and myself both know about this company and equipment. So there was nobody requested one. We didn't do one. So basically that's where we left it.
Okay, and let's take a look at the settlement agreement again. It's defendant's exhibit number 5. Would you agree with me that the settlement agreement itself doesn't identify any procedure for determining fair market value of the equipment if there's a dispute?
That's correct.
And this agreement doesn't identify any valuation expert that the parties would use to determine fair market value?
That's correct.
It doesn't identify a valuation date on which the fair market value is to be determined?
That's correct.
It doesn't include any other agreement about what the parties would do if they disagreed on the valuation?
That's correct.
And it doesn't include any agreement that the parties would try and resolve that dispute with each other somehow?
That's correct.
So with respect to the consideration that came after the execution of this agreement, I want to show you what we've marked as plaintiff's exhibit number 9, although actually, you know what? I think that came in as a defense exhibit. Yeah, sorry, let's actually pull up defendant's exhibit number 6. All right, so this was an agreement that the parties entered into about a year after the original settlement agreement, right?
Correct.
And I'll just call it the 2025 agreement. So as part of this agreement, let's go to section 3 and 4. This agreement provided for an increase in the outstanding balance of both of the promissory notes to $3,412,500, right?
That's correct.
So if you add them up, the increases for both STL and WJS, both of those notes, the increase in the principal amount was $175,000, right?
That's correct.
And there's no agreement in this July 2025 agreement as to how that $175,000 will be allocated among the various classes of assets, correct?
That's correct.
There's no such agreement in the July of 2024 agreement to that effect, right?
That's correct.
In fact, that wouldn't even make any sense because you weren't anticipating you would have this agreement when you entered into the July of 24 agreement, right?
Correct.
And section 5 of the agreement, let's go down to section 5. This talks about a payoff of the loans and leases that BMO had on a number of the WJS and STL trucks, correct?
That's correct.
And this requires TCW or CAST to pay off the balance of those loans by a specific date, right?
That's correct.
And there's no agreement in this July 2025 agreement as to how any of those payoffs are going to be allocated among the various assets that were sold to TCW, right?
You're correct.
And you wouldn't find that in the 2024 agreement either, would you?
No.
Let's take a look at section 9. Now, this is a pretty long agreement, so I'm not going to ask you to read the whole thing, and I'm not going to do it myself. But would you agree that this provides for a mutual release of claims between the parties, WJS, STL on the one hand, and CAST and TCW on the other hand?
Okay, yes.
And the agreement is fairly broad, right? I mean, it says the parties are releasing each other from any claim that each now has or may have by reason of any matter or cause arising out of or related to that 2024 settlement, or the matters alleged in the pleadings in the lawsuit occurring or arising prior to the effective date of this agreement. Did I read that correctly?
You sure did.
And the effective date of this agreement was in July of 2025, correct?
Correct.
And it's your contention that the original settlement agreement required the buyers and the sellers to agree on an allocation of the purchase price, correct?
Correct.
And that agreement or that obligation arose when the parties signed the 2024 settlement agreement, correct?
Correct.
So that would have been about a year before July of 2025, correct?
Correct.
So isn't that obligation one that the parties would have released under this settlement agreement?
Objection, Your Honor. Calls for a legal conclusion.
Is that your understanding, sir?
Overruled, he can answer based on his understanding.
I guess at this point in time, yes.
Would you agree with me that aside from the tax allocation issue that we're here today to address, all the other claims and counterclaims in this lawsuit have been resolved?
Yes.
And it's not your intention to keep litigating those issues that were already resolved, correct?
Correct.
Would you also agree with me that the buyers never prevented you from filing tax returns for STL or WJS?
No, they have not.
And they haven't prevented you from filing forms 8594?
That's correct.
They never threatened to sue you if you didn't complete those forms in a particular manner, correct?
No, they have not.
And if you wanted to, you could file the tax returns for WJS and STL today, right?
I could, but under false pretenses because of the value of the trucks and the routes. I would be lying on a tax form.
Your Honor, I don't have anything further.
All right, redirect.
Thank you, Your Honor. Let's go right back to that room. Mr. Stock, just to be clear, looking at paragraph 9, counsel didn't walk you through this whole agreement. They still owe you money related to the purchase of this business, right?
That's correct.
So there are still obligations that remain after this settlement agreement was entered, correct?
That's correct.
And was it ever your intention to waive the right to enforce the allocation provision in the 2024 settlement agreement?
No.
Okay. So your efforts today are to get the court's help to interpret that provision so that you can file your tax return,
That's
right?
correct.
How many times have you been audited in 30 years of business, Mr. Stock?
0.
Okay. Do you want this to be your first time?
No, I do not.
Okay. And that's why you're pursuing these efforts, right?
That's correct.
Okay. Let's go back to Plaintiff's Exhibit 18, please, on page 11. Council asked you about these numbers here, right?
That's correct.
Okay. So these aren't the numbers from the 2024 agreement, are they?
No, they're not,
And why not?
because there was a lot of addition added there due to the fact of the BMO trucks that were not paid for at the time they took possession of the business.
Okay.
And I had to pay that for about a half a year.
So they had to pay you more money under the 2025 settlement agreement, right?
That's correct.
Okay. And so there was no way of knowing in 2024 that you were going to have to deal with them again and then incur more liability, right?
That's correct.
And so was it your intention by pursuing this to achieve an allocation of the entire consideration that had been paid over the time?
That's correct.
Okay. And have you ever encountered another party that's refused to work with you on achieving an allocation like this?
Objection, relevance.
Sustained.
No, I have not.
Okay.
I sustained it.
Okay.
It's okay.
Was it your intent to try and resolve the allocation with them?
Yes.
And let's go back in time for a little bit. So let's go back to the 2024 agreement, please. And I think that's in, let's see. You got it? I think it's paragraph 9 is closing date. Right above that. There we go. So council asked you about this closing date, you recall?
Yes.
Okay. This said that the closing date was supposed to happen after FXG approval, right?
That's correct.
Okay, did you understand that what was defined as FXG approval in this agreement wasn't really the FedEx approval for the transfer of the routes?
Yes, I figured that they'd have to get approval.
Well, but let's scroll down. So, I'm sorry, I think it's actually back up to the paragraph before. I'm sorry, Kim. Here we go. So here is what was defined as FXG approval. I want you to look down 4 lines. At the end of the 4th line, it starts off, approval shall be deemed to have been given on the date that FXG assigns truck numbers for the STL route and WGS route to Castor its assigners. Do you see that?
Yes.
Did you understand that to mean that that was the FedEx approval for the transfer of the routes?
No.
Okay. So did you understand that by defining it this way, at the closing, they may not have approval to transfer the routes?
That's correct.
Okay. So when we get back to this closing date of December 9th, did they have approval from FedEx to transfer the routes?
No, they did not.
Okay. So who was still liable on those routes after the closing date under this agreement?
I was.
Okay. And how were you going to be able to perform those routes? Did you need to use the trucks?
Yes.
Okay. And let's scroll back up for a second. Right after what we just said, the next sentence says, it shall be CAS's responsibility to obtain the FXG approvals, right?
That's correct.
Was it ever your obligation to get the FedEx approvals of the transfer of these routes for them?
No, it was not.
Okay. Did they have that in place on December 9th when they delivered the funds to you?
No, they did not.
Did they have that in place when you delivered the titles to the trucks to them?
No, they did not.
Okay. So did this deal close on December 9th in your impression?
No, it did not.
Okay. When was it consummated? When did it get completed?
In March.
Okay. Well, let's go back to Exhibit D9. This schedule shows when those routes were transferred by or to TCW, right?
Yes, that what happened was is we received a phone call from FedEx, and they would say this truck number, this truck number, this truck number will be transferred to TCW today.
Today.
Meanwhile, if we were en route or we had to make an agreement to stop the people, it was really horrible to go through. And so she marked the days, and those are the truck numbers that belong to us. So as soon as those went out of service, the mileage stopped on our mileage report on the ELDs, automatically shuts down, and then all the information goes to TCW after that. So we have a deadline on when that stopped and the mileage on the trucks at that time.
But this was not an easy process.
No, it wasn't. It was, I had to hire extra people to come in and help set this back up.
Okay. March is a long time after December 9th, isn't it?
Very much so.
Was it stressful trying to operate the company in
Very,
the interim?
very much so, because we were having problems with employees because they didn't know who they were going to work for. They had heard too many rumors. They didn't know what was going on. So I was having to assure them that they were going to have jobs and they were going to do this because the rumor was out there that this is happening, this is happening. So it was very hard to balance the trucks, the equipments, and keep everything in an operating manner, especially being in two states.
Did you, or strike that, did TCW do things after December 9th that interfered with your ability to operate the truck?
Objection, relevance.
What's the relevance?
Well, Your Honor, he put on evidence or testimony on the cross of they delivered the titles and they're trying to force the closing date point out the closing date of when this occurred. Yet, I believe the relevance is this is going to show why a closing date didn't happen on December 9th.
Okay, overruled.
What happened, Mr. Stock?
So what happened is someone or somehow created an email address for me and started transferring the ELDs, the electronic logs, which the trucks for the drivers and the mileage and all that, started transferring them over into TCW's name, which the trucks were either on the road or getting ready to be dispatched. And we couldn't operate because the trucks have to have an electronic log. We were scrambling to get paper logs so the drivers could go to cover the routes because we were obligated to make those meets and times that we're obligated contractual to. And it was a bunch of disruption throughout both companies from both Albuquerque and New Mexico. And it was kind of a chaos that we had to deal with just to get that. And I don't know how this operation changed. And then somebody was telling our company that I have a contract with the ELDs that I was the one that was requesting this until we found an email address. It was not my email. It was close, but it wasn't it. I was on the highway between Albuquerque and Phoenix when I got the notifications on my phone that the ELDs were going offline, and it said I had requested them and I had not requested them. So it was, and it started messing with our mileage reports with FedEx. There again, I had to bring people in to try to get those mileage reports because we're charged a fuel charge for the mileage that we're not reporting. And if the mileage doesn't match, it's very difficult to make it work. And then FedEx gives us an opt-out for the fuel card. So we're really trapped in having to do that properly. We weren't able to do that. We finally got it cleared up after a few weeks.
So from your perspective, when did this transaction with TCW actually get consummated?
In March, or was the final date was in March.
Is that why you asked the appraisal company to use March as an evaluation date?
Yes, that was correct.
Okay, because that's when you actually turned over the trucks
Yes,
and you had the mileages available to do
yes,
that?
because we had a report that printed the mileage, the ending mileage.
exhibit. We're going to now turn to Exhibit 8, the Rouse appraisal.
Defendant's Exhibit 8.
Defendant's Exhibit 8. Thank you, Your Honor. Mr. Stock, you were asked earlier whether there was a valuation as of December of 2024. Let me point out here at the right above impact of proprietary technology. It's called effective date consideration. Read that for the court, please.
Effective date of consideration, the values represented are based on a March 2025 effective date. Based on observed market trends, values would be approximately 3% higher if December 2024 effectively date had been applied.
So did you ask Rouse to value it in December of 2024 in case the court did determine that was the actual closing?
Yes, we did.
Okay. You obtained the appraisal based on your based on input from the CPA that said you needed that, right?
That's correct.
Okay. And again, we go back to this provision. Let's pull it up, please. D5. In Exhibit D5, 4B, to allocate those amounts for tax purposes, your CPA said get a valuation, right?
That's correct.
Okay. And because you don't want to be audited again, you're going to rely on your CPA to give you advice on how to allocate these amounts, right?
That's correct.
Okay. And if he tells you that putting a number above the fair market value for equipment will violate the rules, is that what you're going to do?
No, I don't want a part of that.
Okay. Counsel asked you before too, he was asking about whether or not they used the names STL and WJS. They didn't buy those names, did they?
No, they did not.
They bought equipment, roots, and goodwill, right?
Correct.
Okay. In all the transactions that you've ever been involved in for the sale of a business or assets, have you ever used language to build in a requirement to file an identical Form 8594?
Objection, relevance.
Sustained. We're just talking about this sale.
Well, Your Honor, is okay. Is it your interpretation for tax purpose? Let me strike that. What is the purpose of this language that talks about an allocation for tax purposes?
Exactly what the wording means, to be able to provide the proper tax allocation for the equipment and the routes.
Is there any other use for this language?
Not to my knowledge whatsoever.
And if it doesn't comply with the tax rules, then it's not a proper tax purpose allocation, is it?
That's correct.
That's all I have, Your Honor. Thank you.
All right. Thank you. Sir, you can go ahead and step down from the witness stand, and don't think you have any other witnesses, correct?
We do not know, Your Honor.
All right.
Thank you.
Just for the record, you rest then.
Well, I guess, Your Honor, we would, subject to the cross-examination of their witnesses, yes.
All right, Mr. Pack, you can call your first witness.
Your Honor, plaintiff's call Chris Cantara. He should be on from the teams.
All right, Mr. Cantara, this is Judge Julian. Are you there? I see you.
I am. Yeah.
Okay.
Can you hear me?
Can you turn your video camera on? There we go.
All right.
All right. Sir, if you could raise your right hand, we're going to get you placed under oath.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah, I do.
All right. Thank you, sir. You can put your hand down and you can proceed whenever you're ready, Mr. Pack.
Good afternoon, Chris.
Good afternoon.
I'm going to show you. I should have waited for you to answer before I started talking. I apologize.
It's all right.
I'm going to show you what we've marked as exhibit number 2, which is a declaration that you had filed in this case. Can you see it on the screen there in front of you?
I do.
I'll just scroll down to the last page. It has your electronic signature. And did you approve the your electronic signature being affixed to this declaration?
Yes.
Now, I know there was one thing in the declaration you wanted to clear up, and that had to relate to paragraph 30. So let's take a look at that. Mr. Cantara, was there something you wanted to clarify concerning the allocation of the purchase price to Roots?
Yeah. So in that, I feel like the wording that I used was not 100% accurate, and that what we're saying is that once the amount assigned to the trucks was used, there was no value left to assign to the Roots, because everything had been, I think, prematurely assigned to Goodwill.
So Mr. Stock testified during his direct examination that he believed that the goodwill value of the company was $5 million because of all the time and effort that he put into building these companies and the reputation he had built over those years. Do you believe that the value of the goodwill of WJS and STL was $5 million without also considering the value of the Roots?
No.
And why is that?
Because